Right away, the temperature in this courtroom shifts. What begins as a routine discovery motion quickly turns into a credibility battle. The defendant insists he was never properly notified. The prosecution says not only was notice sent, it was acted upon. This isn't just about paperwork anymore. It's about whether someone failed to check their email or whether someone is misleading the court. And when a judge starts drilling into specifics this early, you know patience is already wearing thin.
Morning.
Morning.
Okay, any pretrial motions to take up?
I have a couple different pending motions. Motion for discovery. I had submitted a request for discovery. I also have two motions to dismiss. In this case, there were three cause numbers. They've kind of put into the same case. So I'd like to make the court
Let's
aware.
take up your arguments on the first one, which is the notice of pending motions for discovery. Go ahead.
Okay, so you'd like to start with discovery, sir?
Yep.
Okay, we submitted a request for discovery and a full motion for discovery. We have yet to receive anything from prosecution regarding said motions.
You haven't received a date and a time to go review discovery?
Excuse me?
You had not received a date and a time to go review discovery at the prosecutor's office?
No, I did not.
Your Honor, that is untrue. In fact, my assistant, Jennifer Rodriguez, held a discovery conference with the defendant on January 13th, 2026 at 10 a.m. He, however, refused to sign the joint discovery statement.
Yes, Your Honor. At that time, somebody from her office, after I asked for identification, I asked if she was either with the clerk's office or prosecution.
What difference does that make?
It's because I also turned in a PIR request asking for document.
What difference is the fact that she didn't identify herself as a clerk or assistant? What difference does that make with discovery? You're here to argue a motion for discovery.
You're right, Your Honor.
Okay, so you got your opportunity to go and review discovery. What did you get?
I didn't get any of the breadth of what was asked for in our request for
If
discovery.
you didn't get it, they can't use it.
I would, but they're tantamount to my defenses, sir.
If they didn't give it to you, they can't use it.
I received 3 case files from the prosecutor. In one case was the claimant letter, and when they gave me the 3 case files, in one of the case files was the claimant letter and a copy of the citation. The other one was a claimant letter, copy of the citation, and a photo of the front of the Flying Walrus. In the third file was roughly the same.
So
At
you
that
got
point-
discovery.
No, sir. At that point, I asked if I could have email correspondence and that if they could send it to me in email, or that if I would be allowed the opportunity to take pictures of what was in the file. Neither was allowed to me. I was then provided with a pen and a paper and told to take notes.
Why are they required to provide you with pen and paper? Why didn't you go prepared with pen and paper?
If you'll give, no, because I was not alerted that I would be talked to at that moment. I was caught as I was exiting another case. I was here for another case. As I was leaving, young lady stopped me in the hall. At this point,
You
she
had an
handed
appointment
over.
for discovery. Did you go to that appointment?
I did not have an appointment for
The
discovery.
prosecutor just said they send you an email with a time and date for discovery.
She stopped me in the hall. Your
I know
Honor.
they stopped you in the hall, but
That's
you
not
also
an
got
appointment.
notice for a date and a time for discovery.
No, I have not. I have
You
not.
didn't get one. So
I did not
you
receive it.
raise your right hand. Raise your right hand. You swear and test to the fact that you're about to give to this court as true and correct.
To the best of my knowledge, true and correct, I was not provided an opportunity to come in for
I'll hold you in
specific
contempt,
meeting.
Mr. Alexander, if you're lying to the court.
I am not lying. To the best of my knowledge, I was not given to, I was stopped in the hall, Your
Then why
Honor.
did you show up and review? Because you were stopped in the hallway?
Excuse me?
Why did you stop and review? How did you review this?
Oh,
discovery?
I
Because you
wanted-
were stopped in the hallway and you were told, come in and review right now?
This is the moment everything tightens. The judge doesn't suggest, she warns. Contempt. That word alone can change the trajectory of a case instantly. The courtroom falls into a psychological standoff. The defendant doubles down, swearing to the truth to the best of his knowledge, but the judge is laser-focused. She's not debating theories, she's evaluating credibility. And once a judge questions your honesty under oath, every word afterward carries more weight than before.
Absolutely. That's exactly how that went. Your Honor, that's exactly how that went.
Does the
I
state
was-
have a copy of the email that was sent to Mr. Alexander?
I'm looking at the email right now, Your Honor, but I do have a copy of the correspondence that was sent to Mr. Alexander dated the 23rd of December, 2025.
All I have from Your Honor was an objection from the prosecution.
I have the email, Your Honor.
What's your email
I'm
address?
jamesra11778@gmail.com. If there is said email, I simply was not aware of it. Does the prosecution, I had no response to it. I was not aware of it.
The state can't help you in opening up your emails, Mr. Alexander. They met their obligation by sending you a date and a time to come review it. What do you want me to do? You want me to tell the state, now you gotta call him, or you also gotta go by his place of business or home and make sure, let him know that you got the email?
Yeah, Your Honor, honestly, in all fairness, I came into the office, presented both handwritten requests and motions, talked to him directly, sent emails, went above and beyond in my requests.
Okay, I understand that, but we're here for a motion for discovery. In other words, you're here indicating to the court that you didn't get discovery,
I have not received it, no, Your Honor, no, I have not.
but you reviewed the discovery.
I reviewed packets that did not cover the breadth of what was asked for in discovery.
Okay, what you asked for and what the prosecutor has are two different things. Okay, if you ask for videos and there's no video, then there's no video. And nobody can use a video if it comes up all of a sudden because they didn't provide you with a video.
Yes,
So
Your
if
Honor.
you ask for certain pictures or certain documents and they didn't provide them to you, then they don't exist. And if they do exist, they can't use them in trial.
I asked for email correspondence between those that were on the ground and anybody else within the office. They should have
What
access.
are you talking about, email correspondence?
There's officers working on the ground. Yes, Your
Okay,
Honor. And if through our motions to dismiss, there's at least tantamount to the defenses. I didn't want to get too much into like exactly what our defenses would be here. But there's at least some concern about why they were there, because ordinances are usually put in arbitrarily, or because there's been a complaint, or because there's been known hazard, or because there's some sort of permit violation that usually, in this case.
so there's no standard random inspections that can be conducted? Is that what you're arguing?
I would definitely argue that there was nothing random about these inspections.
I'm asking, can there be? I'm not asking whether yours was.
Yes, and
Okay.
I would have be
Let's go
afforded
back
the
to the
opportunity.
discovery then. It seems to me that the state did everything they could to provide you with discovery. If there's no documents or certain things that you asked for that were not provided to you, then they can't be used at trial.
Well, then I would like to.
Let's
if
move
you
on.
can give me a moment, I would like to go through the rest of the things that I was also asking for that I should be able to have.
The rest of the what did you want?
I provided a very detailed list of things that I was
Again,
looking for.
if you didn't get it, nobody can use it. That's it. Just because you asked for it and they didn't give it to you, doesn't mean it exists.
They are tantamount to the defenses I plan on raising.
What?
The defenses I plan on raising.
That's up to you. You have to establish your own defense. If you don't
Yes.
get the documents you use because your plan as to your defense isn't being worked out the way you wanted it to because the documents weren't provided by the prosecution, then that lies on you, not the prosecution.
I mean,
You
I
have
should-
to change your plan or the way you're going to approach this because you don't have what it is you thought you were going
I'm
to get.
operating under the belief, Your Honor, I'm sorry, I apologize, but that I should at least get copies of the offense reports, any and all documents that were taken related to those reports, recordings, and any kind of electronic duplication. That's all stuff right under the Michael Morton Act.
You didn't get the opportunity to review those?
Your Honor, I'm telling you, what I was given was nothing more than the claimant letter.
Then
And
that's
a copy of
all.
the
Listen,
ticket.
you're not listening. You're hearing me, but you're not listening, right?
Your Honor, go ahead.
You got a copy of the claimant letter and the citation, right? Is that what you said?
Am I to believe that the
I'm
prosecution?
asking you a question. Is that all you got? Is that all you saw?
Yes.
Then that's all they can use.
If I may, Your Honor, the state would like to assure the court that we did give the defendant the opportunity to inspect everything that is under the control and possession of the state.
Right, and so whatever that was, that's all they can be used at trial. Just
Yeah,
because you didn't get what you asked for doesn't mean they're holding back on discovery. It means they don't have it. And if they don't have it, then nobody can use it at trial. If you want a video that doesn't exist, the video can't magically appear on the day of trial and the state say, well, now we want to, no, you didn't provide it to the defendant, so you can't use it either.
it's Your Honor, if you give me one moment, please.
Your Honor, I'd like to take this opportunity. Sorry, Mr. Alexander.
Go ahead.
To respond to defendant's assertion that the state or the city cannot perform random inspections, section 138, 337 of the McAllen Court of Ordinances titled Enforcement, Notice of Revocation and Reconsideration. Subsection A states that the provisions of this division shall be administered and enforced by the Director of Planning, and there shall be the right to enter upon any premises at any reasonable time for the purposes of making an inspection of buildings or premises.
At no point.
Here where the legal reality check lands hard. The judge draws a clear boundary. Discovery is limited to what exists. You can demand emails, videos, internal communications, but if they don't exist, the court cannot manufacture them. The defendant's strategy appears to hinge on what he believes should exist. The judge brings it back to fundamentals. If it wasn't provided, it cannot be used. That's protection under the law, not obstruction. The tone now shifts from argument to instruction.
Your Honor, did I make such assertion? There was no need for prosecution to defend herself on said
Okay, let's
assertion.
move on. Go ahead. What else?
Okay, I would just like to know if I'm leaning basically on Article 3914, Your Honor, and additional authorities cited to preserve the record at this time that
There's a record being done. Okay, we got a record going, so there's no problem with that.
For the record at this time, I would like to respectfully object that my full discovery needs were not met at this time by prosecution.
Okay, so noted. Go on.
Thank you. I appreciate the clarification at that time. I'd also like to note this time that and it is my contention that discovery should allow me the meaningful opportunity to prepare the defenses.
Mr. Alexander, this is going to be the last time I
Yes.
address discovery.
Discovery. Would
That's
you like
it.
to move? Would you like to move on? Your Honor? I'm sorry.
Would I like what?
I'm sorry if you were trying to move this on. I wasn't following. I apologize. I'm not trying to be adversarial.
Well, this is an adversarial hearing between you and the prosecutor, but not between you and the court. But I've already
Yes,
made
Your
my
Honor.
ruling on discovery. Discovery was provided. Whether or not you opened up your email is neither here nor there because the prosecution has met their obligation to send you notice. You did, by your own testimony, state that you did review discovery. You didn't get what you wanted. You didn't get everything you requested. And the court has made it very clear that because you did not get what you requested means it more than likely does not exist. And if it does exist, they can't use it at trial against you because they didn't provide it to you.
Then I would just like to note for the record, Your Honor, that I informed, I don't know the young lady's name that you sent from your office, Ms. Borrego? Ms. Rodriguez. I informed her that time after she handed me the joint discovery statement that I was not accepting that as a transfer of discovery. I made that very clear in that conversation. I let her know at that time that I did expect the rest of the discovery and motion and the request to be addressed at that time. She noted said such. She even presented me again with the joint discovery statement and asked me at that time if I would be willing to sign it. I told her, no, it does not cover the breadth of what I was asking for. And while that I was willing in good faith to go under her instructions and write down on the notepad, the notes of what I was provided, that I did not feel that discovery at that time had been completed.
Okay, let's go on.
Yes, Your Honor.
What else do you have to argue, Mr. Alexander?
We are also here for motions to dismiss, Your Honor. Your Honor, there are 3 cause numbers today. I have filed separate motions to dismiss in each case. They do have overlapping issues that I've raised. So I'm not against having them heard together, but of course that's a decision for yourself.
Are the basis of all 3 the same argument?
This is the judge reasserting control. She repeats the ruling methodically, almost clinically. Discovery was provided, notice was sent, review occurred. Whether the defendant liked what he saw is irrelevant. What's striking here is the judge's clarity. She eliminates ambiguity line by line. The courtroom dynamic is no longer chaotic, it's structured. And when a judge starts summarizing her own ruling mid-hearing, it signals one thing: this issue is closed.
They overlap substantially.
What does that mean, they overlap? I don't understand what that means.
The main one is that all 3 involve cases that right now have been cured.
What does that mean again? I don't know what that means. The cases have been cured. What does that mean?
Means that there is no violation for which full compliance has not been met.
Who concluded that?
Prosecution's aware. And
Who concluded that it was already done with it?
the inspectors on site. The inspectors have come in and
Right,
that
but
they've
you
had-
requested a jury trial.
That was before.
No, sir. No, I recall, I was there when I administered that hearing
Yeah,
to the owner of the building, and they offered you the same offer that they gave the owner of the building for a zero fine and to plead
And no
and you
contest.
said, no, I want a jury trial. And that's
Yes.
why we're here.
because I believe that full dismissal and in the interest of fairness and justice is really the only
And we're
way.
here for a jury trial. Let's go.
Yes, we are. At this time.
So they haven't been remedied. Let's go. Move on.
Excuse me, Your
They
Honor?
have not been remedied, Mr. Alexander. The day the citation was issued, the violations were in place. They are occurring. That's why the citation was issued. Whether or
Yes.
not they were remedied after the fact makes absolutely no difference.
They were cured in under 24 hours, Your Honor.
Was there a violation done when the citation was issued?
Yes. but
Okay, then
as
that's what
our
we're
mo-
here for.
As our motion to dismiss also carries out. I would.
Your motion to dismiss will be denied based on the fact that at the time the citation was issued, there was a violation that occurred. Whether or not it was cured half an hour or an hour after the citation was issued is of no significance.
Your Honor, at this time, compliance was achieved. The purpose of the ordinance is compliance and safety.
Right, and
At
at the
this
time the
point, there's
citation
no-
was
there's
issued,
no
neither one of
remedial
them were in
government-
place,
there's
so you
no
were issued a
remedial government
citation. Let's
interest.
move on, Mr. Alexander. Your motion to dismiss is denied.
I would like to preserve at this time.
There's a record being made. Everything's being preserved.
Yes, Your Honor. I would also like to point out that we had a compliant history going back 14 years coming into this. We were never made aware.
What are you arguing now?
The stop on latches, Your Honor.
Okay,
In this case, not only had we had a compliant record going back 12 years, but I'm not here to argue that on the ordinance that said violation could not have occurred or that it did, that there wasn't one. I am contending that it was cured in under 24 hours. But what I'm also contending is that we had reaffirmation from the city over a 12-year period. They continued to renew our permits. They continued to inspect. They had inspections in that time, many dozens over that years, and never at any point were we under any belief that we needed to do these things. If asked, we were willing to comply immediately. And again, that there's simply not a remedial purpose in these prosecutions. That the government, what the government or the city of McAllen has asked for has been complied with. And that we had always operated in good faith. And then in fact, in this point, we had operated in good faith. We had no reason to believe the two violations I am talking to about are a security light in the back alley. The city has, basically the city put in security lights all along the alley back in 2015 and 16. I don't have my phone with me because I'm not allowed, but I have hundreds of photos showing where the security lights themselves, none of them are operational. We were never asked. That's not a defense of our need to do it. It was in reliance on those security lights that we were never asked over a decade to provide any kind of lighting in the back. We simply were not. Our special use permit was renewed. It was first put in 2012. It was renewed again in 2015, renewed again in 2018, renewed again in 2021, and renewed again in 2024. In 4 different renewals, we were not asked for age verification devices, UV markers, or the lighting in question. As soon as we were asked, we complied in under 24 hours. This is noted by inspectors. This is noted by those on the ground. It's just, Your Honor, it's in all fairness, we were rushed into court here. We
rushed into court.
Yes, Your Honor.
This
The
was
city has
this was back in April 16, 2025.
Which cause number are you talking to here? There are 3. I'm sorry, Your Honor.
It has this one for the selling the food without city permit. No, that was dismissed. So this is the building code permit, the electrical work and the construction without inspection.
There was no electrical work. We cleared that up, Your Honor.
Well, that's what I have here.
Yeah, there's been some confusion. And then in that one, the one building permit case, we were actually actively complying.
Okay, but let's go back and focus on your latches, your argument, because
The argument there, Your Honor, is that we had operated for well over a decade.
and so you're
and we-
claiming that
we
the
had-
delay was unreasonable.
The delay,
Is that what you're saying?
if we were made aware all of these things were necessary, we would have complied. We
So-
continued to have our permit renewed every 3 years. And so we were really just relying on their affirmation of that we were in compliance. Anything that we would have been asked when they asked us for another
Hold on,
renewal. of the
let me
permit,
go
we
back
would have
just a
done.
minute. What was the basis of the affirmation you're just made, you made it?
Every time you resubmit for a permit, you're supposed to be
What
in
type of permit?
the special use permit. That's what they're holding of the ordinances are. These are violations based on ordinances.
Okay, your argument is that every time a special use permit is issued, what?
They come through and make sure we are in compliance before issuing or reissuing the special use permit
And in compliance with what?
with
Everything built
with
in,
everything
everything?
built into the special use permit.
In response, Ms. Borrego?
Your Honor, in response to his general argument that the city should be stopped from enforcing this regulation, I'm going to go ahead and refer to a case that he himself cited in his motion to dismiss, which is City of Hutchins v. Krasivka. So I think what happened here is that he basically included cases that had keywords in there, but they don't necessarily apply. And in fact, this particular case states that the city or any governmental body cannot be stopped where there is interference with government functions. I would say that enforcing a city ordinance is a government function, and therefore the city cannot be stopped from doing so.
Oh, I'm not here, and at no point am I arguing that they can't enforce their ordinances.
I know, but you're citing that case.
I'm saying.
Hold on, let me finish. You're citing that case in support of your claim.
Then I'd have to pull up the original motion to dismiss and look at it, if you don't mind. She's pulling one case. There was
I would
several
assume you'd
cases.
have that with you.
Yes, I do. Happy.
That denial lands with finality. The defendant attempts to argue compliance that violations were cured within 24 hours, but the judge focuses on timing. The law hinges on whether a violation existed at the moment the citation was issued, and by the defendant's own admission it did. This is a critical legal pivot point. The emotional appeal of "we fixed it quickly" doesn't override statutory enforcement. The judge isn't interested in speed of repair, she's interested in whether the ordinance was violated.
Pull it up.
And Your Honor, respectfully, the state would like to further assert that this argument of estoppel or latches is in furtherance of his motion to dismiss, and the court has already ruled on the motion to dismiss.
I'm sorry, Your Honor. Is the prosecution contending that, because it's not our assertion whatsoever that you can't enforce your ordinances?
Of course it is. You cited it in the case to support your position.
No, Your
What do you
Honor.
mean, no? I'm looking at it right here. It's equitable, estoppel, latches, bar, retroactive.
I
enforcement.
understood, but the argument is not that they can't enforce their ordinances.
That's what the case law
is that we
states,
have-
Mr.
that we
Alexander.
allowed on
If you didn't read the
intentional
case law and you
reliance.
relied on artificial intelligence to provide it to you, then that's your problem.
Excuse me, Your Honor?
You heard me. This is a ChatGPT motion,
Yes, and of course. I'm
and it
gonna
cited
use
the wrong
everything that I
cases in
can.
support of your argument. So don't come and tell the court I'm not using that case in support of my argument. That's precisely what you do when you cite a case.
Your Honor, I'm not being provided. I need more. I didn't know that I was going to be coming into here debating the case law within the motion. I was coming here.
What do you mean? You come in here prepared like any other lawyer.
Okay, Your Honor. Yes, sir. Yes, sir.
You come in here and you cite cases in your motion. You better be able to support the fact that those cases, in effect, support your argument. But that's not this. This case law is quite contrary to what it is you're trying to argue.
I would like to review that case. I'd like an opportunity.
You
to
provided
review
it
that
to the court,
case. Yes, Your Honor.
and now you're telling me you got to review it? You didn't read the case law?
Yes, I did.
Well, then,
It's
argue
like
it.
I'm not familiar with that case, that part of it.
Okay, let's move on, Mr. Alexander, because I don't have time for you to prepare for the argument here in court.
Yes, Your Honor. Then I concede. Then I'll actually concede. She's arguing that she has the right to said ordinance. I'm not arguing against that. I'm not arguing that let me be clear, please, Your Honor. I'm not arguing that she can't enforce an ordinance. I'm arguing that for 10 years, we relied on the state's own affirmation that we were, or that it was the normal way of doing business that they weren't doing. I've contended to you privately at the bench that I was assured in 2016, because we had another organization called the 17th Street Bar Owners Association, in which Mayor Ron Darling, John Ingram, and then Trevino, I believe it was Trevino.
Mr. Alexander, I'm going to stop
They
you
assured
because
us all
those are not legal arguments.
No.
Those are facts. You want to argue facts?
No, Your Honor.
If you want to argue facts, that's what the jury's for. All that you're telling me now, all those things you're saying that for 10 years or 16 years or however many years, you conducted business without any issues with the city, and suddenly something happened downtown and the city starts enforcing these restrictions. Those are facts you can argue to a jury. But we're here for legal arguments only. Okay?
Yes, Your Honor.
That's why I'm telling you, when you cite a case, that's a legal argument.
Yes, Your Honor. Yes, Your Honor.
What else, Mr. Alexander?
I'd also like to argue that not really here. I'm not trying. Okay. Sorry, I apologize, Your Honor. You used the word argue. So I kind of just repeated it.
I don't know what's left to take up. We addressed the issue of discovery.
I would like
Addressed the issue of dismissal, which included the estoppel and latches, a longstanding cooperation with planning and zoning is a matter of facts, not of legal arguments.
I would say that at this point, and Your Honor, you can go either way with this, is that this court has the discretion, and it's your right to agree or not agree. But I think even the prosecution knows that we are in full compliance, that we were almost immediately, or that we were actively complying at the time we were brought in. And that in all fairness, that there's just not a government purpose in this, because ordinances exist to get the compliance of those that are under them. And I would just at this point, the courts do have the discretion to determine whether or not there is a purpose in pursuing the case and going to trial.
Right.
So while I'm sure you're fully aware of that, I thought that this might be the time to bring that up in this
Mr.
motion to
Alexander,
dismiss.
I'm going to tell you something. I think, and the court stands neutral and detached. I don't take any sides either way.
Understood.
But I think your arguments, not your legal arguments so much, but the facts that you're using to support your position are best presented to a jury, because for all intents and purposes, you may have a legitimate basis with your facts. I'm just saying that a jury may agree with you arguing your facts. The issues with it's unfair, it's biased, it's prejudicial, it violates due process. Unfortunately, those arguments aren't viable, because you've been provided with whatever it is you're arguing you weren't provided with. You may not have been provided with the things you wanted.
Understood.
But fortunately, in a court of law, if you weren't given the, whatever it is you wanted, then nobody can use it. So nobody can use it against you, as well as you can't use it in the sense that you wanted to with your, how you had planned to use it anyway. And as far as being selective and arbitrary, that the city was being selective and arbitrary, you can make your arguments a fact. You can take the stand for yourself and make your own arguments to the jury. You can do that. And I'm just going to tell you that might be I'm not trying to guide you and tell you what to do, but I believe that might be your best approach to this entire trial. You can certainly make legal arguments, but at the end of the day, we've made the legal arguments we're going to make today. That's why we said it for pretrial. But everything you want to tell.
Now the tension escalates into legal substance. The prosecution cites case law, and ironically, it's a case the defendant himself relied upon. That's a dangerous moment in court. When your own cited authority is turned against you, the ground shifts. The judge listens carefully. The prosecution argues that governmental enforcement functions cannot be stopped. If that's accurate, the defendant's estoppel argument weakens significantly. The courtroom energy becomes sharper, more technical, more unforgiving.
Tell me outside the scope of legal argument are considered facts. Facts for a jury or for a judge if this were a bench trial. It's not a bench trial, it's a jury trial. So those things you want to tell me about, you've been in compliance with all these years, you remedied the situation, things of that nature. I think those are best argued to a jury so the jury can decide whether or not you have valid facts that could, for all intents and purposes, lean towards your arguments.
Yeah, yes, Your Honor. I mean, I apologize. I wrote these motions to dismiss 4 months ago, and I received the letter that this motion would, or this email would be happening just a few short days ago. And, just like yourself or anybody else, we're all very busy, and I apologize if we're not being able to answer directly on the case law. I had no fantasy that we were going to come in here. We were going to have a civil rights debate. I wasn't, I didn't think that's what was about to happen.
Was it a civil rights debate?
No.
This has nothing to do with civil rights.
Right. About due process and equal protection and punitive intent and those things. I didn't think that we were all going to go down that rabbit hole. I was right or wrong. I was hoping that the court might operate or exercise its discretion in noting that there was no government purpose for continued prosecution at this time, and that in all fairness, the purpose of the prosecution has been fulfilled. The ordinance has been fulfilled. And
you see those things you're telling me there right now?
Yes. And you're talking about those
are things you should explain to a jury because they're not legal arguments. See what I'm saying?
Understood.
But I think they may carry some weight with 6 people from the community that'll say, you know what? He's right. I mean, he fixed it already.
Your Honor, respectfully, the state is going to object to this line of discussion. It appears that, Mr. Alexander should not be guided into what arguments he should make to the jury or to the court in a pretrial hearing. He understood that his responsibility as a pro se defendant was to defend himself, as would an attorney. And I object to any further.
Understood. Before I go in your objection, so noted. But it's not the court telling Mr. Alexander what to present to a jury. It's telling Mr. Alexander the distinguishing factors between facts and law, and that those things he's telling the court are facts that need to be presented to a jury, and that there has been no legal argument made to support the motions that he's filed. And that's what I'm trying to get through to Mr. Alexander, that everything he's telling me that he wants to use to support his motions are not legal arguments. They are facts. And therefore, those facts need to be presented to a jury. And if those facts are something that the jury agrees with, then so be it. But at the end of the day, that's what the court is trying to explain, elaborate, and hopefully get through to Mr. Alexander so he understands why it is the court denied his motions, because he was arguing facts and not legal precedents or any type of legal argument to support his motions. So, anything else, Mr. Alexander?
I do apologize, and I know that I'm supposed to come here as a pro se defendant, but I'm not an active attorney, and I understand that. So what will be happening moving forward is I will be procuring counsel.
You don't have any more time. Trial's tomorrow.
Okay.
I mean, you can go get a lawyer.
The only problem is that has she, and I'm not trying to get you upset here. She talks about an email that was sent on December 23rd. I still contend I never received so email. Does she have a copy of the
She does.
email that I can read? Because what I did receive from her and what I do have a copy was her objection to my.
This is the most explosive moment of the hearing. The judge directly references artificial intelligence, specifically ChatGPT, as the possible source of flawed legal citation. The implication is clear: if you submit case law, you must understand it. The courtroom dynamic flips from procedural to personal accountability. The judge isn't criticizing technology, she's criticizing preparation. And when she says, "You come in here prepared like any other lawyer," it's not just advice.
Discovery, which I responded to immediately. And was this sent by email only, or was it mailed? No, I did not receive this. I could have gone to spam or something like that, but I did not receive it.
Let's just make note for the record that the prosecutor has provided Mr. Alexander with a copy of the emails that were sent. They've been confirmed by Mr. Alexander that they were sent. They may have gone to a spam folder, but nonetheless, the prosecutor met its obligation to provide notice of discovery. Okay, anything else?
If, Your Honor, just as a point of clarity, if she made the attempt on December 23rd, but then also re-engaged on January 13th, and at that point submitted or at least presented me with a joint discovery statement, and at that point I made it clear to her that we had not concluded discovery, does that not bear weight and
Just means you refuse to sign.
means that, okay, well then I'm just trying to preserve for the record that I do not feel that the breadth of the discovery I had requested had
Again,
been,
that's already been
respected.
addressed.
Yes, Your Honor. As far as the motions to dismiss,
They've been denied.
yeah, denied. I'd just like to preserve my objection.
Mr. Alexander, there's a record of all this.
And I maybe handed to you the first two pages, because I believe the first two pages are relevant. This doesn't matter if they.
Okay, I'm sorry.
Okay,
I'd
Anything else,
like
Mr.
to
Alexander?
preserve for the record
there is a record on
all the
everything here.
arguments
So
within my two motions to dismiss. I heard your. I'm just preserving. I'm just trying to do my best to preserve.
everything's on the record, Mr. Alexander.
Yes, Your Honor.
Anything else?
I guess I've been instructed if we couldn't, I'm not gonna lie, I kind of hoped we might move forward from this, but trial is set for tomorrow. It's not nefarious by nature. I am talking to counsel now, and I will be procuring counsel. That I would humbly like to ask for a continuance from that date, just enough time to bring in counsel.
Your Honor, I'm going to object to any request for continuance. I had a meeting with Mr. Alexander last year. I don't remember the exact date, but I can find it through email. He requested a meeting and indicated during that meeting that he was going to hire counsel. So he's had more than enough time.
I indicated that if we could not come to some sort of conclusion, that I would be sure to look for counsel. And I am now actively doing that. I actually have two different attorneys, both engaged in other cases at this time, that neither could be available today. They're both interested. It was an attorney, John Ball, and an attorney, Dennis Ramirez. They asked me at this time if I could please ask Your Honor for a continuance so that they could make themselves available for this court date.
We've had plenty of time, Mr. Alexander. There have been continuances granted throughout the entire process. So we'll be ready to go for trial tomorrow.
I was sure that this is the first continuance. Okay, but that's fine. Yeah, we'll see how this goes tomorrow.
And just for the record, this case started April 16th, 2025.
That
And this
not
is-
all three cause numbers started in
And this
April.
case has been reset 1, 2, 3, 4 times.
Just for
August the
clarity.
20th, 2025, it was set for trial, jury trial request. So since August the 20th, you've had time to obtain counsel, knowing that it was set for a jury trial already.
And
There
Your
are
Honor-
three cause numbers here, Your Honor,
Nonetheless,
and
You
two
were-
weren't even cited until September.
Your Honor, respectfully, the meeting
They
that.
were not in court.
The meeting that Mr. Alexander had requested took place on October 31st. At that time, the state made absolutely clear. In fact, Mr. Alexander very directly basically said, hey, if you don't dismiss my cases, I'm gonna do A, B, and C. He did indicate during that time on October 31st that he was going to retain counsel. He has yet to do that. I don't think the day before our jury trial is the time to do that.
Could you clarify as to A, B, and C?
I believe during that time, and not that it's relevant, but during that time, you had stated that you were going to be reporting me to the Ethics Commission and other actions that you were going to take.
I have filed a full complaint with the Texas Civil Rights Project, ACLU, Department of Justice.
Okay, those are not court cases or matters that
so
are
I was
relevant
letting
to
you
the
know,
court and the
that's full
trial.
transparency.
So, Mr. Alexander, anything else?
Before we got derated there, yes.
Anything else, Mr. Alexander?
Jesus, wait 1 second. I do want to make sure. I suppose we'll be seeing each other, and, tomorrow, for
Great.
jury selection. at 9 o'clock.
Court's adjourned. We sit for.
This hearing ultimately comes down to 3 decisive rulings. Discovery was properly provided, notice was legally sufficient, and incurring a violation after citation does not erase the original offense. The court made clear that enforcement of municipal ordinances is a protected government function, and reliance on prior renewals does not prevent current enforcement. Most critically, the judge emphasized preparedness. If you cite case law, you must be ready to defend it. In the end, motions to dismiss were denied, discovery disputes were resolved, and the case moves forward toward trial. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.